So in this series, we're talking about risk mitigation measures for regulatory measures by host governments against investments or qualifying investments by qualifying investors. So importantly, from a risk mitigation measures, obviously it's a very broad concept, and there's a number of other measures that could be implemented to mitigate risk. As part of the series, we're only going to talk about three measures fundamentally found within the international investment framework. The first one being political risk insurance that investor could take out in respect of certain potential regulatory measures by a host government. The other is to ensure that your investment, prior to the investment being done, is properly structured. So making sure that there's a BIT in place between the jurisdiction within which you intend to invest and the jurisdiction from which your investment will flow. That ensures that you are provided with certain protection measures flowing from the BIT, as we've discussed in our previous sessions. Other potential is stabilization provisions within investment agreements that an investor concludes with the host government. So stabilization provisions, in essence, ensures that for a particular period, the regulatory regime or physical regime is stabilized over a, say, 10-year period or 5-year period, depending on what you've negotiated with the host government. You also get those in some international mining agreements with particular host governments. So these measures are important, particularly in the mining and energy space, where we're dealing with projects where an investor would spend billions of rands. And with mining, we're talking about you invest in a particular country because of a particular mineral you want to extract. And once the investment cost is sunk, so that you have established the mine, it's not just a matter of deciding I'm going to move the mine from one jurisdiction to another jurisdiction. Your investment cost essentially is sunk. So you are captive to the host government. And if there's changes from a regulatory perspective, if you have not ensured that your investment is properly structured, or you took out political risk insurance, or your investment agreements provide for certain stabilization provisions or adaptive provisions, you ultimately are at the mercy of the particular state, where your only recourse is potentially to the courts of that particular host government, and nothing else. Whereas if you had structured your investment in such a way to ensure that you have BIT protection or treaty protection, you potentially have access to an investor-state arbitration process or other alternative dispute resolution mechanisms to ensure you put pressure on the state to not violate your right or to remediate whatever violation has been done. This includes of the investment agreement. So from this series, essentially what we're trying to convey is to say that it's important that prior to making any investment decision, ensure that you either properly structure your investment, ensure that you have taken out political risk insurance, or in respect of a particular investment, if you have the clout to negotiate that with host government, to ensure there's certain stabilization provisions in the agreement to protect your investment and give you ultimately access to international arbitration.